Hello and welcome to the Hybrid Legal Loop video series, where we will be talking about business issues that we've solved over the years and the typical legal challenges that businesses face here in the UK. And we'll be interviewing our expert lawyers on their insights as to how businesses can solve these common legal challenges. And today in episode 1, we're going to be talking about contracts and what businesses need to think about with their contracts, whether the contracts they're using are fit for purpose or the contracts that are coming into their business are safe to sign. And today's hybrid legal expert, I'm joined by Ollie Harvey. So Ollie, would you like to just introduce yourself to the audience and just give us a background as to your experience as a lawyer?
Sure. So my name's Ollie Harvey. I'm a senior commercial lawyer at Hybrid Legal. I've been qualified as a solicitor for coming up to 13 years. A bit of background. So I've worked nearly my whole legal career in-house. That is kind of working for inside a business as part of a legal team. Previous employers include the largest charity in the UK. I've also worked in the oil and gas sector as an in-house lawyer. I've also worked for a tech startup in the in-house team as well. So my background is primarily aimed at advising businesses how to manage all their legal risks.
Brilliant. Thanks, Ollie. And if we start then, one of the key things that I certainly see when I'm speaking to different businesses about, contracts is lack of contracts, where they've not really thought about putting in place a contract with their customer or their client, or they've just seen a contract as a bit of a tick box exercise and they haven't really read the contract that they're issuing. So just tell us about, why that's perhaps not a good idea.
Absolutely. Yeah. So basically kind of a contract's kind of a fundamental part of kind of doing business with another party. So the kind of main goal of a contract is to identify the roles and responsibilities and obligations of each party, really. So it's basically putting what is perhaps a promise into a legally enforceable document. And the importance of that is that, the key aspects of a contract in terms of when are they going to deliver that, how are they going to pay, what is the actual product they're providing, what are the delivery schedules, these kind of things that we take as part and parcel of business, but actually they need to be documented somewhere to make sure that the seller commits and the buyer commits to pay for the products.
Sure. Yeah, and I think a big challenge really is some businesses will look at contracts and see them as too much of a formality. They worry that it might scare off their client, or they feel that it might be overkill for what they're offering, and they're quite happy to do business on a handshake. Why do you think that's probably not a good idea? And in fact, how would you settle the concerns of someone that thinks actually putting a contract in place is just going to be, an unnecessary burden? What would you say to that person?
Well, I would often challenge that and say that actually I think putting a contract in place demonstrates your professionalism. And these days, everyone from doing their kind of shopping to whatever is entering to contracts every single day.
Yeah.
So I think it's not, businesses don't get put off by putting a contract in place, actually. I think it demonstrates that how you're professional, you're treating this as a legal relationship that you guys are entering into. So I would challenge that and say that actually every business should enter into a contract if you're looking to buy, sell goods or services. And we'll discuss a bit later on about some of the hiccups you can get or some of the incidents that occur if you don't have a contract in place.
Sure, thank you. So tell me about DIY contracts where, a business has cobbled together some terms or used AI to prepare a contract. Tell us about some of the pitfalls and what to look out for with those types of contracts, because I appreciate sometimes they might work, but other times they can go horribly wrong. So it'd just be good to hear from your perspective, where they can go wrong and what businesses can do to avoid that.
Absolutely. So, I mean, the majority of contracts, you sign them, you put them in the drawer, and hopefully you don't look at them again because everything goes well. However, the kind of perhaps 10% of the time or 15% of the time where there is an issue, someone doesn't pay on time, someone's late delivering, actually that's when you get it out the drawer, have a look at it and start scrutinizing it. And it's typically at that point you think, well, actually, I'm glad I invested the time and the effort and the money in putting a robust contract in place. kind of conversely, if you've got an AI contract, AI generated contract, or you've borrowed a set of T's and C's from another party, when you start to interrogate it, you suddenly realize there's holes everywhere. And actually, you want to chase your payment, for example, you realize there's no provision in the contract that allows you to kind of chase a payment or expect payment within a certain time frame. And typically with AI generated contracts, most of the AI tools that people are using these days, they're kind of US generated platforms or tools, if you like. So the content that it's creating is often skewed to kind of US law and not necessarily for the laws of England and Wales, which is 99.9% of our clients are dealing with. So it's obviously a huge risk using an AI generated contract for your general purposes.
Sure. Yeah. And I think, AI, there's certainly some benefits from a cost perspective, from a pure speed perspective, for perhaps using AI to help with contracts. But I think, as you've just pointed out there, there can be some dangerous inaccuracies, some hallucinations as well, which is a thing for AI. And also, I think with simple wording, from what I've understood, even the difference between best endeavours and reasonable endeavours can make a tremendous difference for a business regarding its obligations. Perhaps you could just tell us a little bit more about that difference with wording.
Of course, and I think one of the problems with any AI generated content is a lot of it sounds plausible but is not actually necessarily accurate. And I think in a contract, in order to be able to rely on a clause in a contract, you need accuracy. So it's absolutely unambiguous what it says. When you've got hallucinations from AI generated content, the risk is that, it's not as watertight as you thought it was. And so I would always encourage business owners to perhaps invest initially up front in a robust contract, a good set of T's and C's, because actually you'll be using that day in, day out, for all your business interactions going forwards. And you can kind of sleep well knowing that you've got kind of key risks mitigated. You've got your kind of key aspects of your contract covered, things like intellectual property, debt collection, what happens if there's a dispute, all these kind of areas that are probably really important to you, but actually you've got a robust contract that's been reviewed by a lawyer and it's watertight.
Sure. So looking at some of the key reasons that you've listed there as to why it's a good idea for a business to have a professional contract in place, you mentioned late payments. Obviously, with the current climate, we're seeing, an increased number of clients coming to us to say that their own clients are not paying them on time. That's creating some fairly severe cash flow problems for some businesses. How can they use a contract to help them with that?
Yeah, sure. It's a really interesting one, actually, because it's more and more common these days with, businesses kind of struggling. And I think having a really effective debt recovery clause in a contract is really, it's really beneficial. But I would typically say is when you've got a debt with a particular client is firstly assess, what stage is the relationship at? Because if you start going down the kind of debt recovery route, you potentially risk breaking down the relationship. So it's carefully consider what is your relationship like with this with this client. Sometimes you can actually do a bit of due diligence, look at what their kind of financial position is. Sometimes that might give an indicator as to why they're late paying. So normally in the first instance, you would write a kind of a letter or possibly pick up the phone depending on your relationship, but possibly write a letter stating that the payment's overdue. A lot of contracts have provisions in them allowing you to charge interest on late payments. So sometimes that can act as a incentive to encourage a client to pay quicker.
Sure.
So I'd say that's kind of stage one. If you're still not getting any luck, you'd probably follow up with a call, perhaps director call to say, look, this is outstanding for X number of days. We've got we need to manage our cash flow as well as you do. You may understand that there may be other factors at play, which is the reason why they can't pay. But on the assumption you don't get any kind of feedback from them, then you've got a kind of couple of options to go down the kind of legal route. One of which might be a statutory demand. The other route might be issuing a kind of online money claims form, which is a very simple process, and that can be a way of issuing a claim to a client, which is kind of legally backed by the courts, so you can claim it.
Sure. Okay, so from what I've understood then, when it comes to late payments, make sure firstly you've got a sensible contract in place that covers obviously what happens in the event that there's a late payment. You mentioned that you could potentially apply interest there. Presumably that needs to be in the contract. How much interest can somebody apply to a late debt?
It's kind of at your discretion, but it just needs to be reasonable and not clearly a penalty. So often you find it linked to the kind of Bank of England base rate. So it might be 4 or 5% above the base rate, but that's kind of at your discretion. And what you typically do is in your contract, when you're putting it in place with a potential client, is these are the things you negotiate. So you negotiate what's a kind of fair interest rate. And so it's kind of mutually agreed. So if you do get problems further down the line, every party is aware of what they've contractually agreed to.
Sure. Okay, so you've got the signed contract in place with nice and clear payment terms, bit of interest you can charge as well if they're late on paying you. You've sent them a chaser, sent that letter to say, look, this is X amount of days overdue, and it just feels like you're shouting into the void. Sounds like the next step is, as you were saying, director to director phone call and communication to see if that can bring them to the table to sort it out. If that doesn't work, you were suggesting that there's potentially two options: statutory demand or looking at money claim online to start a small claim. Let's just look at those two in particular. So starting with statutory demands, what is a statutory demand?
Yeah, sure. So statutory demand is not overly dissimilar to kind of submitting a claim, but it's basically it's a judgment. So you apply through a set process. There's a set form you complete. You submit it to the courts. They, on the basis that they grant the statutory demand, it then obligates the debtor to pay within 21 days. If they don't pay within that time frame, they've got risks of potential kind of individual bankruptcy or insolvency, or can put their business into administration. It gets logged on company's house as well, and it's an extra kind of tool, I suppose, to help recover the debt.
And of course, that sounds like it's going to impact your credit score as well,
Correct.
Which is not good news if you're trying to build your credit rating, or indeed if you have investors on board as well. Because I've also heard it referred to as a winding up order,
Correct.
Where you're applying to have that company wound up because they can no longer service their debts. And that sounds to me like it's a bit of a nuclear option to press there. If you, to your point earlier, what's the relationship like? That sounds like, but the relationship is...
That's a relationship ender.
Done.
Yeah.
So that's game over for the relationship.
Yeah.
How about court action? Because I imagine it's going to depend on the value of the outstanding debt will determine which path you take from a court perspective, whether it's small claims or higher. So just talk to us about that.
Yeah, there's various kind of thresholds, but generally the court fee to submit a claim is on proportion to the amount you're claiming for, so the amount of debt. But the court fee is not typically prohibitive to at least issue the claim. And what happens then is once the court issues the claim, the debtor receives notification. They can obviously then have there's three routes, I believe. One of which is obviously kind of pay. The next one is obviously dispute and submit your evidence. The third one is to ask for extra time. So this may be a kind of if they're waiting for a big contract to come in and they're financially struggling a bit, they've got an option to kind of defer the deadline for a slightly longer period to obviously get their house in order, and then the judgment will then continue beyond that.
Sure. Okay. And again, that's the sort of thing that's going to show up on your history, isn't it? When you've got, a county court judgment that goes against you, that's never a good sign, is
No,
it?
and it affects if they want to ever get a loan in the future as well. It's all going to affect kind of negatively.
Okay, so it sounds to me that, businesses do have some tools to use to encourage payment of their invoice. But all of that is on the assumption that their invoice is not disputed, presumably.
Correct, yeah. And often a contract will have a provision there. Say, if you've got an invoice that's generally disputed, then there's certain kind of what's called ADR, alternative dispute resolution, which normally sets out like how the parties are going to agree to deal with any disputes.
Cool. Okay, that's really helpful. Thank you. So carrying on then with reasons why businesses should really think about their contracts. Another key area that I think you were suggesting earlier was around managing expectations. And I think a lovely way of describing this is scope creep, where what you think you've agreed with your client to supply is clearly very different to what your client expects, and you have a mismatch in expectations there. So just, talk to us about, how businesses can manage scope creep in their contracts.
Absolutely, and this point kind of underlines the importance of having a contract in place. Is scope creep, which you just mentioned, is basically setting out the side of the obligation, who's going to provide what, when, for how much money, and having that clearly written in a contract means that it's completely unambiguous. Both parties know what they're getting, when they're getting, and for how much money they're getting it for. Scope creep typically occurs when you don't have that in place. So one party is expecting something much more substantial or delivered within certain timeframes than the other party's willing to give. And scope creep is a notorious problem in a lot of business situations. But it can easily be protected. Having it really, really clearly identified in a contract, totally alleviates any scope creep, because anything outside what you've contractually agreed can either be added on through a kind of variation, or perhaps if you've got a framework agreement, you can add another statement of work that captures this new work. And so you've kind of completely alleviated the scope creep problem.
Sure. And you mentioned there framework agreement and statements of work. Just tell us more about what is a framework agreement and how that works with a statement of work.
Sure. So a framework agreement, again, it's a type of contract, and you typically put in place a framework agreement if you're kind of engaging with a company for kind of a longer term period. And you might have multiple pieces of work that you'll be engaging with the company for. So you'd put in place the framework agreement, which is a contract, and that would be the legals, it's sometimes called. You kind of normally have it for a longer duration, perhaps 2 or 3 years. And then each time you want to place a piece of work with this company, you issue what's called a statement of work. So that would just outline, the key deliverables typically of what you're providing, when you're providing it, and for how much. And so each parcel of work is kind of wrapped up in an individual statement of work. And you can have any number of statement of works going forward depending on how much you're engaging with them.
Sure. Okay. And in terms of, any stories you might be able to share about where you've helped a business manage scope creep, for example, can you share any stories or insights with us that will give us a little bit of a flavour of, how a business has successfully used a contract, to just nip in the bud, the scope creep challenge that a lot of us experience?
Yeah, I mean, I think it often occurs, and I think we've had a client, a particular client based up in the north of England actually, and they had recurring problems with a kind of a supplier that they use fairly regularly, but they were getting kind of late deliveries, sometimes not even getting deliveries at all. Sometimes the kind of costs would seem to fluctuate as well. And so what we did with that, knowing that there was a long-term relationship, was to suggest they put in place a framework agreement, which put a bit of heavy lifting initially because you had to negotiate a framework agreement. But once you got that in place, for 3 years thereafter, for the duration of the contract, they could just place these little statements of work that just ring-fenced the pieces of work. They had it, what they needed to do, when they needed to do it, how much it was going to cost, and they can just place. And I think in that 3 year period, they must have placed about 20 statements of work for all individual pieces of work that could be really easily negotiated between the parties. And it set in motion like a really good, fruitful relationship with, next to no disputes about anything.
Sure. I think another issue that I've seen quite a lot of, particularly as the economic climate has been quite challenging, not just in the UK but further afield as well, is a little bit of bad behaviour with businesses trying to wriggle out of contracts early, an early cancellation. So just talk us through, the importance of having a clear notice and cancellation period in the contract and some practical examples.
Yeah, absolutely. So sometimes this will depend if you're kind of the purchaser of services or goods, or if you're the buyer of services or goods, depending on kind of how you want to, depending on how the relationship is going. But typically, if you're kind of a buyer, you might want to get out of jail clause, if it's called. We typically call it termination for convenience. So that basically just means that for whatever reason, you've got an option to terminate the contract. Perhaps it could be for cash flow issues. It could be for perhaps you've had kind of other kind of issues within the business. It just gives you a right to get out. Now, typically you'd have like a 30-day or sometimes 3-month runoff to be able to for the termination to become effective. But it just gives you that option just in case you need it. And conversely, if you're a supplier, then typically you wouldn't want the buyer just to be able to kind of wriggle out on a very short notice period. So you would, if that is going to be the case, you'd normally insist that you had a termination for convenience clause that was at least 3 months, just so if you've allocated resource and budget to a particular project, it just gives you enough runway to reallocate the resources to somewhere else.
Sure. So, Ollie, tell us about some of the unusual or silly requests you've received from potential clients about contracts.
Sure. There's any number, actually. I don't know how long we've got. But in terms of silly questions, I've had things like, how many words does a contract have to be? Can we stick it on one page? Can we turn the font to size 3? And, the answer is a contract doesn't necessarily have to be complicated. It doesn't necessarily have to be long either. Depending on what you're doing, it probably sometimes dictates on how complicated or how long your contract needs to be, which areas you need to have covered off. So there's not one right answer in terms of how long does it need to be. It just needs to have the right number, right content for your particular services or goods that you're selling or buying.
Sure. And what about the timing of contracts? Because I think there seems to be a bit of a misconception that you can crack on and supply the service or supply the goods, and then you reference your terms of business in the footer of the invoice that you send after you've dispatched the goods or provided the services. Just talk us through why that might be problematic.
Yeah, absolutely. So you're kind of basically saying that the terms and conditions apply to the contract, but you've already done the work. So I would strongly recommend not doing that, in particular because you want your contract in place while you're providing the services. For example, just in case you need to dictate what when you're going to deliver it by, what are you providing them? All the kind of key stuff we've discussed earlier on. There's no good at kind of putting it in at the end, because then it's not. The work you've completed is not necessarily subject to those terms. So the key thing is to put the contract in place prior to undertaking any work. Then you obviously can rely on the contract if you need to, if any issues arise while you're providing the services.
Sure. Okay. And how about businesses that are starting to work with larger organisations or are looking at attracting work from bigger companies? Some may even be household brands. As somebody that's ex-in-house for quite a big household brand yourself, just tell us about what to expect when it comes to the whole contracting process with bigger businesses that will have their own in-house legal teams.
Yeah, so there's often, I think in this scenario, there's often a bit of a David and Goliath situation where smaller businesses feel that they can't propose their own contract, or that they have to take the big company's contract, and it's not strictly true. So people, I would say typically with smaller businesses engaging with big businesses, you'll either send them your contract, which if they've got a in-house legal team, you would expect them probably to kind of mark up, redline all over and send it back to you. Or equally, sometimes they send you kind of their contract and say, look, it's take it or leave it. You take our contract or we don't do business. So you sometimes get both situations, but I'd say on either situation is the key thing is to look at what are they changing in your contract or what are they proposing in their contract. So if they send you their one, don't just sign it and think, well, I've got no room for negotiation, I'm just going to sign it and send it back, because their contract will obviously be heavily drafted in their favour, and you may be kind of committing to things that you can't deliver or perhaps are impossible for you to deliver. So I'd always urge you, if that is the case, is to kind of review the contract, just see what it says. Does it make sense to you? You know, if you need to gauge your lawyer because it's really complicated or high value or really complex, you know, I would suggest doing that.
Sure. Okay. And how about the difference between who you're actually contracting with? And what I mean by that is, you know, if you're a business contracting with another business versus a business that's contracting with a consumer, an individual, what's the difference from a legal perspective, and what do businesses need to be aware of there?
Yeah, absolutely. So I think if you're engaging with another business, generally speaking, it's considered kind of businesses are equal. So you've got kind of equal bargaining terms. However, if you're a business that engages with consumers, you or I buying something individually outside of a business, then consumers have a lot more protections. So there's various consumer right laws in place that protect consumers. So I would strongly urge you need kind of, if you're dealing with consumers, then you need probably a slightly different contract than if you're dealing typically with other businesses.
Sure. Okay. And an interesting area that I see crop up time and time again is around intellectual property, and in particular, who owns the IP, you know, especially when a business is using a contractor or a freelancer to create some form of creative service or products, you know. So just tell us about some of the practical implications to be aware of and what businesses can do to make sure that they're in a good position from an IP ownership perspective.
Yeah, sure. So I think, I mean, we have a lot of clients that are in the kind of creative industries, and so their kind of their business is creating content, creating copyright, which is a form of intellectual property. And so ensuring that if you're engaging with kind of a freelancer to design a logo, for example, or do some artwork for one of your clients, is to make sure that that freelancer assigns the IP to you, so you fully own it. We've seen so many situations where that hasn't happened, and actually the freelancer delivers the goods to you, but actually they retain ownership, so that when your client says, well, look, give me the artwork files, you don't technically own them, so you can't actually kind of license them to your client. And so we've seen so many situations where people come across real big issues when they haven't got the IP ownership right correct.
Sure, yeah, and I've also seen that play out for the corporate team where they've been carrying out due diligence on a business, and part of the due diligence process is to look at the intellectual property ownership history and the proof of ownership, and they'll find that a key asset for that business with the IP is actually owned by a third party. And the reason why it's owned by that third party, as you say, is because there is no contract which expressly says about the IP ownership transferring, usually once full payment has been received. You know, so they're in that tricky situation where they've now got to knock the door, cap in hand, to say, any chance you could sign this bit of paperwork completely out of the blue? Sorry, we've not spoken to you in years, but can you sign this? And we might pay you, an extra X amount of pounds. And of course, that's where you're creating leverage for that person then, which is always a bit awkward.
Yeah, we had an exact example of that where we had a client that had used an image for their website and some brochures. And when they started looking back, they realised that they didn't actually have any right to use it. So the owner of the copyright said, hold on a second, that's my image that's on your website, that's on your brochures, that's on your sales collateral. And they were like, oh, sorry, okay, well, look, we'll put a licence in place. You know, he can almost charge any fee he wants. You've already got all this collateral, you spent a lot of money on it. And, you've got no leverage whatsoever.
Sure. On the topic of charging fees in contracts, just talk to us about, penalties in contracts? Because I've seen, again, this goes back to the DIY contracts and messing around with templates without either knowing what you're doing or taking professional advice. I've seen some silly clauses over the years where there'll be a ridiculous financial penalty if a certain event happens, and it's in there clearly as a deterrent. But just talk to us about what's legal and what isn't legal when it comes to penalties in contracts.
Yeah, absolutely. So I think that using the term penalty is probably the incorrect term, actually, because under English law, you're not permitted to kind of have penalty clauses in a contract. So what you typically have, and you see it quite often, is for late delivery. So say you're kind of, each day you're late, you pay kind of 1% of the contract value. Now, when you're trying to work out what that figure is, that figure needs to kind of be proportionate to what your losses are for it being a day late, 2 days late. By putting in a penalty or a clause that's completely unreasonable, it's going to mean that clause is unenforceable.
Sure.
So you can't rely on it. So the important thing is, if you're looking to put in a liquidated damages clause for late delivery, is to make sure that it is proportionate to the loss you're going to suffer for delivery being late.
Sure. Okay. So what about signing contracts? Are e-signatures safe to use?
Absolutely. So I think in this day and age, and I think it was really kick-started through COVID when people weren't in offices to physically sign contracts. And so e-signatures, are permissible, provided they kind of follow certain procedures. And, there's well-known kind of e-signature tools, DocuSign, etc., that you can kind of legally sign a document, but you need to ensure that you have the right e-signature program to allow you to do that. And I think importantly, often they'll have a kind of a signature receipt attached to the contract. Will have the time, date, the name of the signer, also the title of the signer as well, so it's kind of crystal clear who signed it, when they've signed it, and it's not kind of a fraudulent signature.
Sure. And connected with signing contracts, can anyone sign a contract on behalf of the business, or is it only certain people in a business that can legally bind that company in the contract?
So it kind of depends on normally you have like things called standing financial instructions, for example. So particularly bigger companies and certain individuals within the company, probably certain roles, would have like permission to sign on behalf of the company. So I think in terms of that, it's probably check what you've got, what your company has in terms of what's your kind of authorization for signatures. But in theory, if your employment contract, permits you to sign on behalf of the business, then, you can sign on behalf of the business.
Great. Okay. So how about contracts over email? Can I just reply to an email to say that I'm happy with the terms, let's crack on, or is that not legal?
Absolutely. So, you can commit to a contract via email. You can also do it verbally. Obviously, then you might have some difficulty proving it because there's not the evidence. But I think in order to answer this question, it's probably easier to go back to say kind of how was a contract formed. And so you've got to have, an offer, acceptance, consideration, which is payment, money, and also an intent to create legal relations. So to your question about an email, can you confirm a contract via email? Yes, provided there's a clear intent to provide legal relations, then absolutely, a contract is formed. You're committed to what you've agreed to.
Okay, and in terms of language that you're using there, is there a difference between a contract and an agreement? And also a deed, because you hear about deeds, you hear about agreements, you hear about contracts. Well, what's the difference between them all?
Yeah, so good question, actually. So in terms of kind of terminology, like a contract and agreement is in effect the same thing. Deed is slightly different in terms of how it's signed. So a deed would need to be kind of signed by both parties. It would also, both signatures would need to be witnessed by another party as well. This all needs to be carefully documented in the deed. Not so common, apart from in property matters, you might come across deeds, but contract and agreement, same thing.
Cool. Okay. And when it comes to dealing with larger businesses where you're going to be dealing with an in-house legal team, What are the key things in your experience, obviously being an ex-in-house lawyer yourself, that the legal teams are always going to really be keen to look out for in a contract? And just some practical tips for businesses in terms of what they can ensure in their contracts.
Yeah, absolutely. So I'd say kind of number one on there is what's called indemnities. Now, everyone's probably kind of seen them, but people probably seldom really understand what it means. And so kind of translate it. An indemnity is basically responsibility. It says who's responsible for what. You'd often have then a limitation of liability saying, well, how much, what's a maximum amount each party is going to be liable for under the contract. So there's probably the two most critical ones that an in-house lawyer would look out for. And equally, if you're looking at a contract as a business looking to engage with somebody, they're the ones to make sure you've got it really clear about who's responsible, liable for what, and also what's a maximum amount. If everything goes wrong in the contract, what's the maximum amount you're going to be liable for or responsible for? And you'd have that as a limitation of liability. This kind of second, third, fourth most, I'd say things like confidentiality. A lot of big businesses, they want to keep certain projects incredibly confidential. Perhaps if they're working with a government agency or doing something else, that they want to keep the project, the fact you're working with them, confidential. So that's kind of the third one, I'd say. And the fourth one is data. Is there going to be personal data involved in your transaction with this other party? Is there going to be any data transferred? That's obviously a really key one now since the Data Protection Act 2018. There's a real spotlight on data, and a lot of companies seek to protect the data they're potentially sharing with you as part of the contract.
Sure. Okay, so at a high level then, for anyone watching that's thinking about working with larger businesses with in-house team, just quick fire summary of key things to make sure are covered as a minimum in a contract. What would you summarise?
So I would say the key things to look out for is number one is indemnity. Number two is confidentiality. Number three, data.
Cool. Okay, that's really helpful. So for the audience and anyone watching or listening, what would be your number one takeaway for them? If they do nothing more than this one thing, what would it be?
My number one would be, if you don't have a contract in place, put one in place, get one drafted. If you do, is just check it. Make sure that it's up to date. I've seen clients with contracts that's referencing legislation that's been surpassed, 25 years ago.
Yeah.
So I'd say, you've got a contract in place, just annually, just check it, make sure it's kind of suitably robust and covers what you need it to do.
Yeah, and of course services change, products change, and making sure that's reflected in a contract makes sense, doesn't it? Otherwise it's a bit awkward when you hand over an old contract to a new client and they actually bother to read it. First impressions really count, and I see it as a new business tool almost. You want to really impress your client when they read your terms to see that it's actually nice and up to date, well considered and fair as well.
Absolutely, because I think fair is a really good point actually, because you don't want your contract to be one-sided, because then every single interaction you have, is redlined, everyone's crossing everything out, I need this change, it just actually delays it. So making sure that your contract is fair and proportionate for your services, you get much less pushback from clients and a much more smooth process to get them signed up to the T's and C's, you're good to go.
Brilliant. Great. Well, that's it, Ollie. So look, I'd like to say thank you very much for sharing your insights today. I mean, I know I've certainly learned a bit, and I've been working with you for a good while now, and I'm hoping that our audience have learned from your insights as well. But, obviously if they have any questions, they're welcome to get in touch, and we can hopefully help from that.
Absolutely. Absolute pleasure.
Right, thank you very much for listening today. I hope you found, obviously, Ollie's insights useful. If you would like to hear more useful insights coming up, please subscribe to our Hybrid Legal Loop email series. That's where I'll write to you every other week. No sales pitch, but I'll be sharing with you, some useful legal tips to help your business. Please also go onto YouTube and sign up to our video series so you don't miss our upcoming episodes, one of which is going to be talking all about buying and selling a business and what to expect from a legal perspective, where I'm going to be joined by my Mike and Shelley, who are in our corporate team, and they'll be sharing their legal insights as to what you can be thinking about if you are thinking of acquiring or selling a business. And we're also going to be talking about some employment law changes coming up. So please do subscribe. And if there's anything that you'd like to discuss with us, you can find our details on screen. Please do get in touch. Otherwise, thanks for listening.